We've covered a lot of ground so far on this video, but just in case someone happens to be skipping around to the different topics, why don't we recap very briefly and talk about motions to dismiss or motions to suppress certain types of evidence, whether it's chemical or blood test or whatever. What are some of the ways that you do that?
Well, a motion to suppress in district court can be done orally. You don't have to file written motions. If you're up in Superior Court, you actually have to file a written motion and have supporting affidavits. But there are motions to suppress for lack of articulable suspicion. Basically, the stop was bad. And those are all based on the Fourth Amendment, that it's an unreasonable seizure. There are motions to suppress for lack of probable cause, that the arrest was invalid because they didn't have enough probable cause to arrest. There is a motion to suppress for what I call the 20-minute rule, but that vague area somewhere between articulable suspicion and probable cause if they don't have enough grounds to keep detaining you. So those are three general areas. Then there's the multitude of motions we've talked about to suppress a breath test or a blood test based on all sorts of different issues.
I've seen on television where people talk about a motion to suppress, but I've also seen the TV lawyers stand up and say, we're asking for a dismissal, Your Honor. Can you walk me through that? What's the difference between a motion to suppress and a motion to dismiss?
Well, a motion to suppress only suppresses evidence. A motion to dismiss dismisses the case. Now, as a practical matter, if you win on a motion to evidence based on the Fourth Amendment, then all evidence that is gathered after an illegal seizure is suppressed and the case is over. You win the case. So a motion to suppress based on the Fourth Amendment typically means you've won. Now, that's true of articulable suspicion. If they didn't have a valid reason to pull you over, all evidence is suppressed. If they didn't have a valid reason to arrest you, all the rest of the evidence is suppressed. But now if we talk just about breath tests, if they violate one of the statutes on breath testing and they suppress the breath test, that doesn't mean that the case gets thrown out. You then can go to trial with the driving, the field sobriety test, but no breath test ever mentioned. So typically suppressing a breath test is a huge victory and can result in a dismissal.
Something I haven't asked you about throughout these conversations is due process. We hear it again, going back to television, you'll see TV lawyers get in court and they talk about due process. What does that mean for someone that has been stopped for DWI, they've gone through all the blood tests or chemical tests or whatever, they've gotten in touch with you, you're getting ready to go to trial? Does due process come into play at all?
Absolutely. You have a right to a fair trial. And in DWI situations, routinely the state is not able to get all their witnesses together. And so what happens in a lot of DWIs is after the case has been continued a bunch, the judge finally says, well, I'm not granting any more continuances. And the state doesn't have their witnesses ready to go forward, so the state will take a voluntary dismissal of the case. Now, typically the client is, oh great, you got my case dismissed, but it was not guilty, and it was not dismissed by a judge. It was voluntarily dismissed by the DA so they can refile charges.
Oh, okay.
And a lot of times they do refile charges and start the process all over again. Well, I've been very successful at getting Superior Court judges to say, no, that's a violation of due process. If a district court judge has already ruled that this case has been continued too many times, ultimately it's speedy trial.
Right.
But it doesn't really fall under speedy trial, it falls under due process of law. So that you're entitled to a fair hearing, and the state can't use a procedural method of dismissing and refiling as a backdoor way of getting a continuance. So due process absolutely is alive and well in DWIs.
Well, that takes us to something that's a big topic, and I know you have a lot of questions about this, and we're going to try to answer them. That's the topic of sentencing, when it comes time for sentencing, and we'll do that next.